Judgment in the matter of the Crown on the application of Wang and another against the Secretary of State for the Home Department.
The UK's immigration rules contain a number of points-based regimes whereby people may qualify for permission to remain in the UK if they can show that they score a specified number of points referable to their skills, their status, or other characteristics. This appeal is about the Tier 1 investor migrant regime, designed to enable high net worth individuals to obtain a right to remain in the UK if they made a substantial financial investment in the UK. It is no longer in force, but this is a test case because the applicant, Ms. Wang, was one of over 100 people who made use of a specially designed scheme, I'll call it the Maxwell scheme, which was intended to ensure that its participants qualified for the required number of points under the regime. The essential requirements to obtain the requisite points under the Tier 1 investor migrant regime were that the individual had either £1 million of their own money in the UK or net assets of £2 million elsewhere coupled with £1 million in the UK borrowed from a UK regulated financial institution and, in each case, had invested £750,000 in specified classes of investments within a stated time following entry to the UK. In both cases, the rules required that the owned or borrowed £1 million be under the applicant's control. This control requirement lies at the heart of the case. The Maxwell scheme was designed for those who, like Ms. Wang, had the requisite offshore net asset value, but did not want to bring £1 million of their own money into the UK for investment. Under the scheme, a UK company called Maxwell Asset Management Limited, I'll call it MAM, was to lend £1 million to the participant for 5 years, which was then to be invested by the participant in another company called Eclectic Capital Limited, which I'll call Eclectic, by way of loan convertible by the company into preference shares, paying a dividend lower than the interest rate payable by the participant to MAM. Both MAM and Eclectic were beneficially owned and controlled by a Russian couple, Mr. and Mrs. Kirpichenko. So was MAM's parent company, Maxwell Holdings Limited, which I'll call Holdings. Participation in the Maxwell scheme cost £200,000 paid up front to Holdings as a services fee, and its terms were set out in 3 standard form agreements between the participant and MAM, Holdings and Eclectic, respectively. The money borrowed by the participants from MAM and invested by them in Eclectic was then reinvested by Eclectic almost exclusively in Russian companies. The Secretary of State refused Ms. Wang's application for leave to remain in the UK as a qualifying Tier 1 investor migrant on 2 grounds. The first was that at no time did she have the money borrowed from MAM under her control, because it was always predestined to be invested in Eclectic. The second was that Eclectic was a type of investment vehicle that was excluded under the rules. Ms. Wang's application for judicial review failed before the upper tribunal, which agreed with both of the Secretary of State's reasons for refusing leave to remain. But the Court of Appeal reached the opposite conclusion. While concluding that the Secretary of State had been entitled to take the view that Ms. Wang had no choice other than to invest the borrowed money in Eclectic, this did not mean that the money was not under her control for the purpose of the rules. The Court of Appeal considered that the control requirement was only designed to ensure that the borrowed money was available personally to an applicant to invest, rather than just as a nominee for somebody else. They also considered that it had not been shown that Eclectic was an excluded type of investment vehicle. This court has unanimously decided that the Secretary of State and the upper tribunal were right, and that the Court of Appeal wrong about the meaning and purpose of the control test and its application to participants in the Maxwell scheme. Ms. Wang therefore failed to qualify as a Tier 1 investor migrant, whether or not Eclectic was an excluded type of investment vehicle, a point which this court did not therefore need to decide. I give the only judgment with which Lord Kitchen, Lord Burrows, Lady Rose and Sir Declan Morgan all agree. Our reasons are, in summary, as follows. First, The issue as to the meaning and application to Ms. Wang's case of the control test in the Tier 1 investor migrant regime is to be determined by applying ordinary principles of statutory interpretation to the relevant parts of the immigration rules. The question is whether, viewed purposely and in its context, the control test is or is not satisfied by Ms. Wang's participation in the Maxwell scheme, viewed realistically. The fact that the control test is one element in a point-based immigration regime does not mean that it is to be interpreted in some other way, as was submitted on Ms. Wang's behalf. Secondly, the purpose of the control test was too narrowly identified by the Court of Appeal. It was not merely to ensure that mere nominees did not qualify as investor migrants, which was in fact ensured by other provisions in the rules, but to ensure that qualifying migrants had a real choice in the investment of the £1 million in the UK, whether their own or borrowed money, and could make their own decisions about what to do with it. This accords with the natural and ordinary meaning of the phrase, and I quote, "under his control," quotes off, in the rules, and there was no purposive or contextual reason to give it some different or narrower meaning. The Court of Appeal and the Upper Tribunal both concluded that, looked at realistically and in the round, the Maxwell scheme did not give participants any real choice as to the use or investment of the £1 million borrowed from MAM. On the contrary, the money borrowed by the participants remained under the effective control of Mr. and Mrs. Kirpichenko throughout. As this case was a judicial review, the question for the court was whether this was a rational conclusion already reached by the Secretary of State. In this court's view, it was not only rational, but was the only realistic conclusion on the facts about the Maxwell scheme. It was both inconceivable that MAM would have lent the money to a participant like Ms. Wang on any other basis than that it was to be invested in Eclectic, and inconceivable that, if free to do so, a participant would freely have invested the borrowed money on the disadvantageous terms upon which it was required to be invested in Eclectic. For those reasons, the appeal is allowed, and the Secretary of State's decision to refuse Ms. Wang leave to remain is restored. The court is now adjourned.